Now calling to order the case of Jordan Street versus Reese Taylor. Counsel, if you'll introduce yourself.
Good afternoon, Your Honor. My name is Imo Kyle Kolo, and today I have the privilege and honor of representing Jordan Street, the mother of Rory Street.
Okay.
Good afternoon, Your Honor. My name is Kevin Littlejohn II, and I, along with my co-counsel, Ms. Madeline Light, are here today proudly representing the defendant in this matter, Coach Reese Taylor.
Okay, plaintiff, I'm going to give you your 5 minutes for pre-trial, and when you start talking, I'll start the timer.
Absolutely. Your Honor, I just have a few housekeeping matters. This is a new experience for all of us. We're on Zoom here, Your Honor. Throughout the course of today's trial, there's obviously going to be some objections that come up. I just ask that if Your Honor is okay with me staying seated for the course of objections throughout the course of today's trial.
Of course, and I'll stop the timer just so y'all are tracking. I'll try to announce what time I've got when the objection comes up, okay?
Additionally, Your Honor, I anticipate there may or may not be some impeachments that happen throughout the course of today's trial. Now, if we were in Your Honor's courtroom, typically you may not see the document as we're impeaching a witness, but for the purposes of this Zoom call, Your Honor, would you mind if we do impeachments by way of screen share so we all can see and know what's going on?
Any objection from defense?
No objection, Your Honor.
I don't have a problem with that.
And lastly, Your Honor, the plaintiff's counsel, we would just like to bring your attention to the fact that there are pre-admitted exhibits in today's case. Your Honor has that pre-trial order, and I just wanted to let Your Honor make sure Your Honor was aware that there are pre-admitted exhibits we will be using throughout the course of today's trial, two of which are expert testimony.
Okey-dokey.
And with that, Your Honor, I have no further housekeeping matters. I can say substantive motions to eliminate for after opposing counsel has some housekeeping matters if you'd like.
Let's just do your motions to eliminate now.
Awesome. Your Honor, I just have one motion to eliminate. That being, we have a good faith basis to believe opposing counsel may be trying to use a note. For Your Honor's references, this is Exhibit 12. We believe that there's improper authentication for this note pursuant to Rule 901, Your Honor, and for them are the notice hearsay.
Okay. Response?
Yes, Your Honor. We do object to this motion. First, addressing the authenticity argument. Your Honor, Federal Rules of Evidence 901 will allow for authentication through handwriting if it is testified to that there's a familiarity with the handwriting. Your Honor, today we will have a witness that will be able to testify to the familiarity with their handwriting, and that will be a teacher of the decedent, Rory Street. And now, in addressing the hearsay argument, the actual statements, if Your Honor would like to hear them, are actually then existing mental state, which is an exception under Federal Rule of Evidence 803.3, the then existing mental state. And I pulled the exhibit up. Would Your Honor like to hear the statement?
Sure, let's hear it.
The statement reads as follows. Clint, I really like the snow you sold me yesterday. Can I buy some more? Let me know in health class.
What about that as expressing a mental state?
It's a plan to purchase more, Your Honor, and that is something that can be testified to.
Let him finish.
Your Honor?
Yes.
I don't believe that qualifies under Rule 803.3, Your Honor. That is a then existing state of mind, such as intent, motive, plan, or some type of physical condition, Your Honor. That's not met in this document. They're not talking about some sort of physical condition or mental condition they have at the time. And it's certainly not outlining some sort of plan to make purchases of this snow in the future, Your Honor. It's asking a question, and it's simply not within the bounds of 803.3. It's not the intention of that rule, Your Honor.
Your Honor, may I be heard?
Yes, you can.
No, it is a plan to purchase cocaine. It directly aligns with what a plan would be if you were trying to buy drugs. It says, I really liked what I bought yesterday. Can I buy some more? And trying to buy some more and reaching out to someone to find where to buy it is planning to buy cocaine.
Mr. Colo, is it your position that a plan is in the ambit of the rule?
Your Honor, I do believe that, intent, motive, or plan are listed in the rule, but I don't believe this is a plan, Your Honor. And furthermore, for opposing counsel to suggest this is a plan to buy cocaine, then the word cocaine is not even mentioned in this document, Your Honor. And if Your Honor,
hold on. I'm going to go ahead and I'm going to overrule the objection for now. When it comes up in testimony, you're free to raise it again, and we can talk about it then. But I'm going to overrule it for now insofar as the motion's concerned. Okay.
Certainly, Your Honor. And with that, we have no further motions to eliminate and are ready for opening statements.
Okay. Defense, your 5 minutes begins when you start talking.
One, Your Honor, I'll first address a housekeeping matter that I have as well. Is it okay with Your Honor if I actually do my direct examinations, cross-examinations, and obviously objections from the table and then do my opening and closing while moving about the will?
Absolutely.
Thank you, Your Honor. Additionally, I do intend to have deposition testimony read today, and I would like Your Honor's permission to allow my co-counsel, Ms. Madeline Light, to read the answers.
Permission granted.
Thank you. All right, now I'd like to turn to our substantive matters as well, please. By way of brief background, Your Honor, this is a wrongful death suit that the plaintiff has filed against Coach Reese Taylor of Waco High School. We believe the evidence today will show that Reese Taylor did not breach the ordinary duty of care that she owed to the decedent and was not the proximate cause of the decedent's death, because you'll find out, Your Honor, the decedent was under the influence of an illegal substance. Now, I want to first ask Your Honor, you've previously stipulated to two exhibits being authentic, one being Exhibit 14, an autopsy report, and the second being Exhibit 15, a toxicology report. Both reports come from the medical examiner's office here in town, and because they're authentic, it means they are what they purport to be, which allows them to be an exception under hearsay under the public records exception. And we ask that they go ahead and be pre-admitted.
Response?
Your Honor, we don't believe that meets the exception as a public record, specifically the toxicology report, the second exhibit that opposing counsel was referring to. A toxicology report is not a public record, especially for a minor who was 17 years old at the time, Your Honor. We don't believe that the public has ample access to any sort of toxicology report from the medical examiner's office, Your Honor.
Response?
Yes, Your Honor. First and foremost, I do believe the actual decedent was 18, if I'm correct. And however, it's still a report while the medical examiner made it while under a legal duty to report it. Whether or not it's put out into the public or not, it's still a public record. It's a public office that has produced the record.
Okay, I see the distinction. What's the response to that?
Your Honor, just because a public office produces a document does not mean that that document is subject to the public records exception.
That's right, but given the additional qualifications that it was made, under an investigation, pursuant to an investigation, isn't that what's needed to meet?
It is one of the prongs under Rule 803.8, Your Honor. But however, we do believe that there is some circumstances that lack trustworthiness in this document. We understand that, this toxicology report was only tested by one doctor. We do believe the circumstances surrounding this toxicology report make it are questionable in this circumstance, Your Honor. Pursuant to Rule 803.8, that is one of the prongs that must be met, is that the circumstances must not indicate a lack of trustworthiness. And we believe that it indicates a lack of trustworthiness, as both experts today, in today's case, from my side and plaintiff's side, agree that there was very nominal amounts of cocaine in the system. Given that, Your Honor, there could have been a flaw in the test, there could have been something wrong with the test that was performed, and the opposing counsel wanted that medical examiner to come in here and testify, they could have.
Your Honor, if I may be heard briefly.
Mm-hmm.
That argument goes to weight, not admissibility. The opposing counsel wants to argue that in closing argument, that's perfectly fine, but that's a decision for you to make.
I would strongly agree with that whether the conclusions reached, that's something for me to evaluate. You're free to make that argument that, just like you did, right? And I can evaluate that. That doesn't go to the admissibility of that report. So hold on, let me finish talking. So the way we're going to split the baby is this way. Not going to pre-admit it. Go ahead, unless you're planning on using it for your opening.
No, I'm not, Your Honor.
So insofar as you don't need it for your opening, just go ahead and try to admit it. You can raise the objection, then we can take it up then. Anything further for pretrial?
Yes, Your Honor. Opposing counsel, am I correct in taking that he has not objected to Exhibit 15 being pre-admitted, the autopsy report?
We have no objections to the autopsy report being pre-admitted, Your Honor.
Okay, then it's admitted. And anytime something's admitted, you can go ahead and publish it. You don't have to ask me whether or not you can publish it, although you're free to.
Thank you, Your Honor. And then additionally, we also believe that there may be testimony offered before you here today that somehow insinuates that Coach Taylor had a propensity to put her hands on her students. Coach Taylor did have an incident at her previous school while she was younger, in which she did discipline a player by putting her hands on her. However, under the federal rules of evidence, since this is a civil case, there can be no propensity evidence used. Therefore, that specific bad act is inadmissible at trial here today.
Any objection to that?
Your Honor, we don't anticipate in going into that specific prior bad act.
Okay, so then I will I'll grant that motion, avoid going into the prior bad act.
And at this time, Your Honor, that concludes my substantive motions.
Okay, good deal. Already right on time. So we can begin with the openings. Like I said, you'll have 5 minutes. I'll try to announce after each time that you talk how much time you have remaining. As soon as that you start talking, Mr. Okolo, I will start the time.
Thank you, Your Honor. May it please the court and opposing counsel. The defendant knew there was something different about Rory Street at soccer practice on September 7th, 2018. The defendant's best player she had ever coached suddenly couldn't do anything right under heat that reached 105 degrees. But instead of asking if she needed a break, if she needed some water, or if something was wrong, the defendant pushed and pushed and pushed and eventually ran Rory to death. That's why we're here. Good afternoon. Once again, my name is Imokai Okolo, and I have the privilege and honor of representing Jordan Street, the mother of Rory Street. Before I tell you about how this defendant prided winning and success over the health and well-being of Rory, I gotta tell you a little bit about who Rory was. But most importantly, who Rory could have been. This is Rory Street. Rory Street grew up right here in Waco, Texas. At the age of 4, Rory was a soccer prodigy. Her mom got her involved in the sport because it was something her mother loved to do as well. She figured, hey, if I was good at the activity, maybe my daughter will be too. The minute that ball touched Rory's feet, everyone knew she was going to be something spectacular. She was dribbling around, taking shots. I mean, it was amazing what a 4-year-old can literally do with a soccer ball. As time went on, you see Rory began to get better and better at the activity, and she grew to be the next, Messi or Pele, the next greatest soccer player there ever was. That's who Rory was. A gift to our community. But in order for you to really understand what got us here to this point, you got to understand the responsibilities of a Texas high school soccer coach, the responsibilities of the defendant. See, throughout the course of today's trial, you're going to learn that the defendant wanted to keep up with best practices in the industry. Time and time again, and year after year, the defendant would go to various clinics and various workshops to learn what are the best practices for a coach in my position. Just months before this incident even happened, the defendant's going to admit that he attended a training. And at this training, he was informed of the precautions and the seriousness of health concerns for their players in extreme heat, so especially here in Texas. We all know that here in Waco, for it to get above 100 degrees, that's not unusual. It's probably just another Tuesday here in Waco in August, right? So it's important, and we'll learn throughout the course of today's trial how important it was for Coach Reese to take those necessary precautions to avoid injury in the heat for their students. You'll learn he knew about that before September 7th of 2018. However, you'll learn just what kind of coach Reese Taylor was. She'll tell you that specifically, she enjoyed training in the heat. She thought it would toughen the students up. She intentionally had practice in the afternoon and would run them for hours and hours on end with very little breaks and water, maybe if they so choose. This coach was tough, pressuring students one after another, constantly putting pressure on these students to be tough, be great, work through the pain. And that's what got us to September 7th of 2018. See, on that day, the temperature was rising. You see, the defendant looked at the temperature and said, hey, today's a great day for another practice. Had them all go onto the field around 3:15 p.m. and figured, I'm going to toughen my students up today. We got some good heat. If I toughen them up, maybe they'll be tougher for the end of the season. So we're going to run a full scrimmage. Have the entire team on the field, no shade, for an hour running and practicing and scrimmaging each other in this heat. As time went on, the coach began to notice, well, Rory was acting different. This coach was used to Rory being the star player, the leader on the team, setting the example of how a great student should be. But after an hour in playing and scrimmaging under that heat, Rory began to miss simple passes. Couldn't position herself right on the field, was missing wide open shots. The defendant tried to encourage her. The defendant tried to give her advice, but it seemed like Rory wasn't comprehending what was going on. But instead of asking her for a break, asking if she needed help, asking if something wrong, the defendant decided to punish Rory. Punish her for not being tough enough. So she sent her to Burma Road. You're going to hear that Burma Road was a drill that was ran on the practice field next to where they were. Burma Road required you to run 30 yards as fast as you can, dribble a ball 30 more yards as fast as you can, shoot on goal, bear crawl back another 60 yards, and do it over and over and over again until coach told you to stop. You're going to hear from a student on that team, Aubrey. Aubrey's going to tell you that she was actually running Burma Road before Rory got there that day. When Rory got over to Burma Road, Aubrey's going to tell you that she was noticeably tired, noticeably exhausted. Her skin was pale. She looked lifeless. It was as if something was wrong. She was having chest pains, finding it tough to breathe, but she was still running and running just like Coach Taylor told her to. But Coach Taylor looked back over. Felt that Rory was dogging it, wasn't giving it her best effort. She says, hey, if you think you're special, I'll show you just how special you aren't. Created this new drill out of thin air. No breaks, no water, no shade. Had Rory come over from Burma Road and participate in what we call a slide tackling drill, unlike anything this coach has done before. Had the entire team line up in front of Rory. Rory stand there with a soccer ball, and that team, one after another, would run up to Rory, try to take the ball away from her using a slide tackle, and knock her down every single time. Time and time again, Coach Taylor would blow the whistle, a student would run, slide tackle Rory would fall, collapse to the ground, and just struggle to get back up. Again, she would fall to the ground, struggle to get back up, fall to the ground, struggle to get back up. And she fell so hard one time, the coach had to pick her up by the back of her jersey, told her to get up and stand there and do it again. It was on that 15th time that Rory collapsed and couldn't get back up. She started grunting and began to have a seizure. You're going to learn that Rory died on that day because of cardiac arrest. Cardiac arrest that was brought on by a heat stroke. You're going to be able to have the opportunity to listen to Dr. Reagan today by way of deposition, Your Honor. Dr. Reagan is going to testify that the reason Rory died was because no one looked after Rory. Rory's body was unable to cool down in that heat because Rory was exhausted. Rory was pushed to her last limits. Now, I anticipate opposing counsel will get up here and try to blame Rory for what happened. Say that it was something Rory did, maybe something Rory took that caught us to this point today. But that expert is going to explain to you that no amount of drugs, no amount of anything would have led to Rory's death, and that the symptoms that were testified to by people who were there all align with heat stroke. Your Honor, we're here today because this defendant's tactics, this defendant's attitude disregarded the health of their students and prioritized winning at all costs. It's because of this defendant's actions that a mother lost her child, that a high schooler lost her best friend, and that our community lost a kid that was extremely special. It's for these reasons that at the end of today's trial, Your Honor, I'm going to ask you to stand up for Rory and stand up for the countless other students being coached by Coach Taylor and find her responsible. Thank you.
Okay. 45-39 remaining.
Thank you, Your Honor.
Mm-hmm. And give me a second, I'll pull your time up. Okay, 55 minutes, Mr. Littlejohn. As soon as you start talking, I'll start the timer.
Yes, Your Honor. Permission to readjust my webcam?
Absolutely, and I won't start the timer for that. Anytime y'all need to readjust, just go ahead and do it, and we'll hold until you're ready.
Ready to proceed, Your Honor.
Whenever you are.
May it please the court. When someone ingests dangerous substances, they run the risk of its deadly consequence. And on September 17, 2018, the decedent, Rory, ingested a dangerous illegal substance, cocaine. And as she was on her practice field going through a regular practice, she tragically fell victim to the deadly consequences of cocaine. Judge, this story starts a few days before September 7th, 2018. It's soccer season here in Waco, and the decedent is well within soccer season for herself. She's got school soccer practice during the week. She's got travel soccer practice on the weekend, and her mind begins to get pulled several different ways. She's got to decide where she's going to commit her athletic abilities to for college. She has to figure out how she's going to be able to successfully keep her grades up. She has to navigate how to keep her parents happy. And with all this on her mind, she begins to lose control. You see, the decedent has to deal with another reality that many high schoolers face. She's now being pressured to use drugs. The decedent, who's no stranger to popularity, who's no stranger to all the recognition, gets approached by a fellow classmate about doing cocaine. And instead of resisting the temptation and peer pressure, the decedent falls victim to it. And she ingests that substance. Now, the decedent is not familiar with how cocaine will react with her body, so she continues to go through her normal daily routines, and that's when September 7th, 2018 happens. The decedent is on the practice field, in the middle of a scrimmage during that practice, when suddenly she's unable to dribble the soccer ball that she normally is able to dribble. When she's unable to hit shots that she's normally able to score. And she's unable to field passes that she usually would be able to field. Her coach, the defendant, Coach Taylor, notices this. And as soon as she notices this, she addresses it. She sends Rory through a few drills. And the last drill she sends her through is a slide tackling drill. And as Rory is going through this drill, the unimaginable happens. Rory collapses to the ground. Coach Taylor immediately tries to get the decedent help, but it's too late. The decedent lost her life on that field. And tragically, a few days later, Coach Rory learned that the decedent fell victim to the deadly consequence of cocaine. Judge, the decedent's decision to ingest that dangerous substance and her result of falling victim to that dangerous and deadly consequence is why we're here today. Now, what opposing counsel failed to mention is that this is a negligence action and that the opposing counsel is the plaintiff. And they have a burden of proof here today. And what they have to do is bring to you the evidence you will need by the greater weight of that evidence to convince you that Coach Taylor breached the ordinary duty of care that was owed, and that Coach Taylor's breach of that duty of care caused the decedent to tragically lose her life. In your honor, opposing counsel will fail to meet that burden here today. Now, in an attempt to try and convince you otherwise, as you just heard, you'll hear from a live witness and other testimony. And when opposing counsel calls the friend of the decedent before the stand, Ms. Saracen, you'll learn that on September 7th, 2018, Miss Saracen completed and did the Burma run longer than the decedent. So I have to admit that only Miss Saracen and the decedent ever talked about how the decedent felt that day. And then once you hear from Miss Saracen, you'll then hear testimony from the mother of the decedent, Jordan Street. And Your Honor, I want to be very clear. We know that what Miss Street is going through is traumatic. And we by no means intend to blame her daughter for what happened. But when you hear this testimony from Coach Street or from Miss Street, you'll learn that she actually encouraged her daughter to show no pain, to show no weakness. To find out that Miss Street actually participated in the Burma run herself when she played soccer. And that Miss Street supported Coach Taylor initially coming to the school. And then lastly, as you heard, you may hear some expert testimony from the plaintiff. And no matter what you hear, I want you to understand that the plaintiff's expert is not a toxicologist. You actually find out the plaintiff's expert has never once testified at trial at all. But once you hear from the plaintiff, you'll then have a chance to hear from our witnesses. And the first witness you will hear from today, Judge, is Coach Taylor. And Coach Taylor is going to take this stand, and he's going to talk with you about how, or she's going to talk with you about how she loved to coach the game of soccer. How over her over 20-year career of coaching, she never once had a player to tragically lose their life. And you'll learn that she was never once told that the decedent needed a break, needed water. And then, Your Honor, I want to read some deposition testimony from the trainer for the Waco County High School soccer team. It's going to be Trainer Merriweather. And you'll learn from that testimony that Trainer Merriweather was at practice observing the team that day. And learn that Trainer Merriweather was never made aware of Rory or anybody on the team saying that Rory needed a break. And then you also learn that in Merriweather's class, there was a suspicious note with the decedent's initials on it. And then finally, you'll hear from our expert testimony. And we're going to bring before you Mr. London, who has a degree in toxicology, who's testified over 200 times in different cases. And you will learn that on September 7, 2018, there was a dangerous substance in the body of the decedent, and that dangerous substance tragically led to the deadly consequence of the decedent losing her life. So at the conclusion of all this evidence and testimony you'll hear today, Judge, I'm going to come back before you. And I'm going to summarize all the evidence and all the testimony that you hear today. And I'm going to ask that you return a verdict finding that the defendant is not liable. And I'm confident this is something that you will do today because the evidence today will show that on September 7th, 2018, it was the decedent's decision to ingest a dangerous substance that ultimately resulted in the tragedy of the decedent falling victim to that substance's deadly consequence. Thank you, Your Honor.
46:51 remaining. All right, I believe we're ready to start the case in chief. Let me get the timer set. Okay. 45:39, you can proceed however you'd like, Mr. Okolo. You can call your witness, or if you're going to read something in, just I'll start the timer when you start talking.
Thank you, Your Honor. At this time, the plaintiff would like to call by way of deposition Jordan Street. We're going to have my second chair hop on the screen here. We're going to read portions of that deposition for Your Honor.
Sounds good. When y'all start reading, I'll start timing.
Starting on page 2, line 6 for the court's reference. Good morning. Please state your name for the record.
My name is Jordan Street.
Where are you from?
I live in Waco and have all my life.
Do you have any children?
I did. My daughter, Rory.
I'm showing you what's been marked for identification purposes as Exhibit 3. Do you recognize this?
Yes, this is the photo of Rory.
Is it a fair and accurate depiction of Rory as she appeared on September 7th of 2018?
Yes.
Your Honor, at this time, we move to admit into evidence Exhibit 3, which has been previously shown throughout my opening statement.
No objection, Your Honor.
It's admitted.
Thank you, Your Honor. Page 3, line 11. Was Rory in high school?
Yes.
Where'd she go to school?
Rory went to Waco High, just like me.
Did Rory participate in any sports?
Yeah, she played varsity soccer for the school. She played soccer for a private traveling club team on the weekends. To be honest, that kid's life was pretty much soccer 24/7. Getting her to read a book was a hard part.
When did Rory start playing soccer?
Oh gosh, when she was little, 4 or 5 years old. I went and signed her up to get her just being out and being athletic and being around other kids. But she took right to it and never looked back. Before you knew it, we were spending weekends driving all over Texas to soccer tournaments, and the next 12 years or so were just kind of a blur. Soccer tournaments, soccer practices, soccer camps, soccer everything.
Page 6, line 10. Was Rory a troubled kid?
No, Rory was a good kid.
Did she use drugs?
Absolutely not.
Objection, Your Honor. This is speculation.
Okay.
If I may, Your Honor.
Yeah, let's look. Can I hear the basis of the objection first? Just, it was speculative, the question.
Yeah, yes, Your Honor. The question that was previously asked on line 10 was, or line 12 was, did she use drugs? The mother testified absolutely not, but the mother is not with Rory all times of the day, especially not in school. So she wouldn't have the ability or the perception that's required under speculation to say absolutely not.
Response?
Your Honor, this is the mother of Rory Street. This is just her rationally based perception as to her understanding of what her daughter did and did not do. Opposing counsel knows that we're going to be talking about this toxicology report and the medical examiner's report that shows there could have been cocaine in Rory's body at that time. We're not disputing that fact, Your Honor. She's just giving her rationally based perception.
Okay, I'm going to overrule the objection. I'll just instruct the jurors to note that, of course, the witness was not omniscient. She couldn't have known everything about her daughter, but I think, otherwise the testimony can continue. Whenever you start talking, I'll start the time again. You have 43:46.
Thank you, Your Honor.
Did she use drugs?
Absolutely not. If I had suspected that or even seen any evidence of that, there would have been serious consequences. Whenever Rory acted up in the past, even just threats of grounding and chores around the house proved to be effective deterrents. I have no idea why the test showed that, but it couldn't be accurate.
Page 7, line 13. You told us earlier that you've lived in Waco your entire life. Did you go to Waco High?
Yes, I did. I'm a Lion through and through.
When you were at Waco High, did you play any sports?
I played soccer, just like Rory, but we won a state championship while I was there.
When you were playing soccer at Waco High, did you ever have to run Burma Road?
Hell yeah, we did. I remember doing that when we were dogging it, or if we weren't in the correct position or something, coach would send us off to run Burma Road. But I'll tell you this, none of my coaches ever made me or any other kid keep going when it was obvious that we were exhausted. Discipline is one thing, but that's just dangerous.
Page 8, line 3. Do you know what a slide tackle is?
Sure.
Are slide tackles a part of the game of soccer?
Of course they are. Turn on any game and they're going to see players at every level performing slide tackles. That's just part of the deal.
Are slide tackles violent?
They can be. I mean, it's soccer, so a lot of injuries are pretend, acting. But at any time you're running full speed and you slide feet first at another player's legs, that could be a dangerous situation.
Is it important to teach slide tackling as a coach?
1 second. Yes, it is. But that isn't what happened here. This wasn't a drill to teach Rory how to slide tackle or defend against them. Rory knew how to slide tackle and how to avoid them. This was about punishment. Coach Taylor lost her temper.
Objection, Your Honor. Again, I believe this is speculation. The witness is testifying to what Coach Taylor did, why Coach Taylor did something, and that's speculation. She's pervading the mind of Coach Taylor.
Your Honor, she's not talking about Coach Taylor's thoughts and feelings. She's given her perception as a lay witness of what she believed happened to her own daughter that day, Your Honor.
That may be her.
I'm going to overrule the objection and allow it. Again, I'll give the instructions. Ms. Taylor wasn't omniscient when she was giving this testimony or at the time that she observed the things that led her to her conclusion. She's only testifying as to the conclusion she reached based on the observation she had.
Okay, thank you, Your Honor.
1 second to restart the timer, 41:47.
Is it important to teach slide tackling as a coach?
Yes, it is, but that isn't what happened here. This wasn't a drill to teach Rory how to slide tackle or defend against them. Rory knew how to slide tackle and knew how to avoid them. This was about punishment. Coach Taylor lost her temper and went too far. This drill wasn't necessary. And all the time that I've played, coached, and watched soccer, I've never seen a drill like that. Not once.
And with that, Your Honor, we have no further testimony from Ms. Jordan Street.
4114, you can call your next witness or begin.
Your Honor, if I may, at this time, maybe constructively cross-examine the deposition.
If it's all right, I'd just like to keep it to your own case in chief. You can go back and read portions of the deposition with co-counsel, if that's all right, just that way we can keep this clean and organized.
If co-counsel is fine with it, I am as well. If opposing counsel is fine with it, I am as well.
Is that fine?
Yes, Your Honor.
I mean, certainly it's just deposition testimony. You can read it.
Okay, thank you.
At this time, Your Honor, we'd like to call Aubrey Saracen to the stand.
Okay. Ms. Saracen?
Yes.
All righty. She's been previously sworn, and when you start talking, I will start your timer 4114.
Thank you, Your Honor.
Yes, sir.
Good morning. Good afternoon, rather. Please introduce yourself to the members of the jury.
My name is Aubrey Saracen.
Can you tell us a little bit about yourself, Aubrey?
Yeah, I'm born and raised in Waco. I go to Waco High School and I'm a senior there. And I'm 18 and I'm going to Rice University after high school.
Congratulations, Aubrey. While you were in high school, did you play any sports?
Yes, I played soccer and I was on the varsity soccer team for 4 years.
Are you familiar with a student by the name of Rory Street?
Yes.
How do you know Rory?
We grew up playing soccer together our whole lives. I've known him for known her for a long time. And we played on the varsity soccer team at Waco High together.
She a good soccer player?
Yes, she was fantastic. She was one of the best players on our team.
I want to talk about September 7th, 2018. Do you remember that day?
Yes.
How did that day begin for you?
That day began with going to school and having soccer practice after that at 3:15. And we were doing a scrimmage that day.
Who runs your soccer practice?
Coach Taylor.
What are your opinions about Coach Taylor?
Coach Taylor made our team successful, but I never agreed with her coaching tactics, and she seemed to use intimidation and yelled at us a lot and did things to scare us to play well.
Was that happening on September 7th of 2018?
Yes.
How so?
Well, to start off the practice, or about an hour in, I was told to go run Burma Road for not playing well. And Burma Road is a difficult thing to do in the first place, but later on, whenever she told Rory to go do that is when everything changed.
Before we get to Rory running Burma Road, can you tell us what it is?
Yes, Burma Road is where you run for 30 yards, dribble the ball for 30 yards, and you kick the soccer ball into the goal and then bear crawl 60 yards back.
Is it just a one and done kind of thing?
No, we just continued to do it until Coach Taylor told us to stop.
Now, you said you had been running Burma Road when Rory came over.
Yes.
What did Rory look like when she came over?
She looked pale, looked like she was exhausted. And I asked her if she was okay. And she said she was feeling funny and had chest pain.
Did you guys continue to run Burma Road?
Yes.
Did you have a break while you were running Burma Road?
No.
Did you have any water while you were running Burma Road?
No.
How about some shade?
No.
What happened when you guys were running Burma Road?
We were running Burma Road and Rory was very tired and didn't look well. And then coach yelled at her for her being lazy and looking tired, and had said that she wasn't special and that she was going to show Rory why she's not special.
How'd she do that?
She called Rory back down onto the field to do the or where the scrimmage was on the field, and lined everybody up or the rest of the team in a single file line, and had Rory stand about 15 feet in front of them to do the slide tackle drill.
Before coach had them run that slide tackling drill, did the defendant give her a break?
No,
Did the defendant give Rory any water?
no,
How about some shade?
no.
Did you hear the defendant ask whether or not Rory was okay?
I didn't hear that.
Did you hear her ask if any of the students were okay?
No.
Now, during this slide tackling drill, tell us what's going on.
So the players who were aligned in the single file line would run towards Rory, who was dribbling the ball, and they would attempt to do a slide tackle, which is where they would slide down and try and kind of kick the ball out from where Rory was dribbling it. And in doing that, a lot of times the players will kick their shins or will cause someone to fall over. But in this circumstance, it was those players were just going one by one at Rory.
Was Coach Taylor there while this was going on?
Yes.
While this drill was happening, what was Rory looking like?
Rory was still looking pale and like she wasn't doing well. And it was concerning.
Had you ever seen Rory in this state before?
No, I haven't. And in the past, Rory has been really tough and has played through full soccer games with a broken nose and not complained of anything. So it really stood out to me that she complained to me about how she was feeling.
As this drill was going on, was Rory falling?
Yes.
What would happen when Rory fell?
Coach Taylor would walk up to Rory and would pick her up by her jersey to get back up.
How many times did this happen?
15 times.
And on that 15th time, did Rory get back up?
No.
What happened?
He or she had been on the ground and it looked like she was starting to have a seizure and she was shaking and convulsing, and everyone just went to swarm around her to make sure she was okay, and she never got back up.
Do you remember how hot it was at practice that day?
Yes, it was really hot, probably over 100 degrees.
Did Coach Taylor ever tell you they were going to take precautions for the heat that day?
She did not.
Did the defendant tell you she was going to give you guys extra breaks and extra water because it was so hot?
She didn't.
Do you remember if you even took any breaks?
I don't remember taking any breaks.
Thank you. We have no further questions for this witness, Your Honor.
33:39 remaining. Let me set the clock for cross. 46:51, you can begin and cross. I'll start the time when you start talking.
Thank you, Your Honor. Good afternoon, Ms. Harrison.
Good afternoon.
Can you hear me clearly?
Yes.
If at any point in time during this examination you don't hear my questions, feel free to ask me to repeat, and I'll be more than happy to oblige. Now, before we discuss what happened on September 7th, 2018, I want to first talk a little bit more about you. Now, as you just testified, you and the decedent, Rory, were pretty close friends, right?
Yeah.
And you two actually grew up playing soccer together, correct?
Yes.
Played Little League soccer together,
Yes.
travel ball, and ultimately high school soccer together, right?
Yes.
And when you two weren't playing soccer together, you oftentimes would spend time at each other's homes, right?
Good.
And one of the interesting and fun things about your relationship with Rory was that you actually got to share the field with Rory on the soccer team, correct? Your junior year, you both started on the same side of the field, right?
Yes.
However, your senior season, that changed, didn't it?
Yes.
In fact, you lost your full-time starting position your senior year, right?
Yeah, but it wasn't that big. I mean, I was upset, but it wasn't a big deal. I was just glad to still play with the team.
I understand, but you lost that starting position not to just anyone. It was to Coach Taylor's kid, right?
Yes.
And you thought that decision was crap, didn't you?
At the time, yes, I did.
And you are aware that the way this litigation is set up today, that Rory's mother has brought a suit against the coach that took your starting spot away, right?
Yes.
Now, I want to transition and talk to you more about your friendship with Rory. Now, because you were so close friends with Rory, you all would talk frequently, correct?
Yes.
And on September 7th, you thought she was appearing to be stressed, correct?
Yes.
But when the two of you talked, she told you she wanted to be a normal student. She wanted to relax, right?
Yes.
She also told you she wishes her mom would get off her back.
Objection, Your Honor. All this is here. This testimony is here.
Okay.
Not
Response.
for me to respond. Yes, Your Honor. According to Federal Rules of Evidence 8033, this is a mental feeling that the declarant / decedent had when she made the statement. The mental feeling was that she wanted her mother to get off her back, a feeling of pressure, anxiety.
Your Honor, the statement itself does not have any feelings or any emotional conditions. Saying that I want my mother to get off my back or I want to be a normal kid does not show some sort of feeling, Your Honor, within the realm of 8033 or emotional condition at the time.
Your Honor, I still re-raise my previous argument. However, if you do find opposing counsel to be persuasive, it can be offered for a not for truth purpose, which is the circumstantial evidence of the declarant's state of mind, still being that she's frustrated, she's suffering from anxiety, pressure.
If I may, Your Honor,
You may briefly.
the opposing counsel is using this for the truth. On opening statements, he got up here and told us that the reason Rory was doing drugs was because she was stressed, because she felt like she didn't want to be in school anymore, that she felt like she wanted to be a normal kid. They're offering it for the truth.
If I may, Your Honor,
Sure. Shortly.
it still doesn't necessarily mean that she actually was wanting to be a normal kid or that she wanted to relax. It just means that she felt as if she needed to. It can be offered for a not for truth purpose.
I'm not seeing the distinction there. I apologize, but that doesn't seem to make sense to me. Okay. So let's figure out how we can take care of this one. Okay. It's an out-of-court statement. I agree. I think it's being offered for the truth of the matter asserted. You're trying to establish the truth that she was, in this mental place. That being said, let's revisit the first ground that it was her then existing mental state. I mean, I think that's also true, right? That's the very definition of how she was feeling. I mean, I think the objection to that exception basically was that, it's not I feel bad or I feel sad, but feelings can be complex. And I think that can be a reasonable expression of her emotional state. Do you have a brief response to that, plaintiff?
Your Honor, we just don't believe that this is an expression of her actual emotional state, Your Honor. How she actually feels about the situation of her parents having her do sports or her wanting to be a real kid, we don't wanting to be a normal kid, rather, Your Honor. It doesn't give us an actual expression of if she was feeling good, if she was feeling bad, or how exactly she was feeling about her situation.
So I would say, I mean, to that explanation, I mean, feelings are much more complex than I was feeling good or bad. We're all teenagers in this room, and we all had some big, complicated emotions. So I'm going to allow the testimony to continue, and I'll overrule that objection. 44:14, when you start talking, I'll start the timer again.
Thank you, Your Honor. I'll repeat the question, Ms. Saracen. And when you two talked, she said she wanted to be a normal student and relax, didn't she?
Yes.
She said she wishes that her mom would get off her back, right?
Yes.
And you would agree with me that it's usually a bad feeling to feel as if someone's all over your back, correct?
Objection, Your Honor, to speculation. He's asking her to speculate as to if she felt good or felt bad about given those statements.
If I may respond.
You don't need to respond. I'll go ahead and overrule the objection. The question was, if you were confronted with this situation, would you feel bad? That is not asking to speculate as to the decedent's mental state. Rather, the question was asked, would she feel a certain way? She can certainly testify to that. If it starts going the other direction, raise the objection again. You're at 43:49. When you start talking, I'll start the timer.
If that's the case, Your Honor, I would like to re-raise another objection as to relevance. Her feeling at the time is not relevant to today's case, whether or not Coach Taylor acted reasonably or acted in accordance with the standard of care he should have.
Briefly, go ahead.
Yes, Your Honor. The bar for relevancy is extremely low. The federal rules say evidence is relevant if it has a tendency.
The bar. Tell me how this is relevant. How it slightly moves the hand in some way or another.
Yes, Your Honor, because if a teammate of Rory would have believed that having your parents feel as if you're on your back is a bad thing, that can result in making bad decisions. And that's why it's relevant, because as we get through this testimony, it's going to further say that stress and feeling bad can lead to bad choices.
Yeah, I'll overrule the objection. I'll allow the testimony. 43:49 when you begin talking again.
Now, Ms. Saracen, now, you would agree with me that a bad feeling can cause stress, correct?
Yes.
And people different people react differently to stressful situations, right?
Yes.
Some people turn to exercise.
Yes.
Some turns to friend and family.
Yes.
But there are times when people turn to drugs to react to bad situations, correct?
Yeah.
Now, I know you mentioned you and Rory were pretty close, but you weren't with Rory 24 hours of every day, correct?
That's correct.
And you don't know if the times you weren't with her, she was actually taking drugs, do you?
That's true. I wouldn't know that.
Now, I want to switch your attention now to September 7th, 2018. And I understand that that's a very traumatic day for you as you lost your friend. So if you need to take your time and gather your composure, feel free to do so. Now, as you mentioned, on September 7th, you two had soccer practice, right?
Yes.
And even though it was September, you've been practicing since August, correct?
Yes.
And on that date in question, you just mentioned that it was hot outside on September 7th, correct?
Yes, it was.
But you were practicing in Waco, Texas, right?
Yes.
And this wasn't your first summer practicing soccer either, was it?
It was not.
In fact, Rory and yourself practiced soccer in the summers in Waco ever since you were little, correct?
Yes.
Now, you would agree that it wasn't unusual for it to be hot in the summer, right?
Yes.
And it also wasn't unusual for Coach Taylor to instruct you and your teammates to do the Burma run at practice either, right?
Right.
Now, up to that point on September 7th, 2018, before Rory tragically lost her life, you had never been made of any single player that had passed out or lost their life while doing the Burma run, had you?
I don't believe so.
Never been made aware of any single player that Coach Taylor passed out or lost their life during any drill that Coach Taylor designed, have you?
I don't believe so, from my knowledge.
Now, as this practice was developing, you just testified that you were doing the Burma run first, right?
Yes.
And you were doing the Burma run longer than Rory was doing the Burma run, correct?
Yes.
And you didn't pass out on September 7th, 2018, right?
Right.
So as you and Rory were on this Burma run, she never once told anyone other than you how she was feeling, did she?
She didn't.
She didn't tell the trainer.
No, she didn't tell the
And
trainer.
as far as you know, she didn't tell Coach Taylor.
That's correct.
And you never heard Rory ask for water either, did you?
I didn't hear him ask or hear her ask. No,
You never heard her ask for a break.
that's correct.
You never heard her ask for any shade.
Yes.
But y'all can get water whenever you ask for it, right?
I'm sorry. What did you say?
But you can get water when you want it, right?
Yes.
Now, eventually you said Coach Taylor removed Rory from the Burma run and pulled her over to do the slide tackling drill, correct?
Correct.
Now, slide tackles are something that's common to the sport of soccer, right?
Right.
Something that players experience during the game, right?
Yes, but not 15 times in a row.
And we'll address that as well, but just for now, that's something that's common to the game that you experience, correct?
Yes.
Now, you would agree with me that it'd be beneficial to practice something that you're going to perform in a game, right?
Yes.
Now, slide tackles aren't usually dangerous, are they?
I think it would depend on how hard you got hit, but not typically.
Now, I want to talk about the way this drill was set up because you just told opposing counsel that the way the drill was set up was that Coach Taylor told the team to line up on one side of the drill and for Rory to line up on the other, right?
Yes.
Now, at this point in time, Rory was the best player on your team, correct?
Yes.
With skills that were better than everyone else, right?
Yes.
And you said that Coach told you all to get 15 feet apart?
10 yards away.
Oh, so it's 10, so they're actually 10 yards apart.
Yes.
So with you being 10 yards apart, the best player on your team had 10 yards between her and her opposition to avoid a slide tackle, correct?
Yes.
Now, as this drill was happening, Rory never once told Coach Taylor that she was tired, did she?
She didn't.
Never once asked for a break.
She didn't ask for a break.
Never once asked for water either, right?
That's right.
Now, I know this may be difficult to address, but once Rory collapsed to the ground, Coach Taylor and the trainers called 911, right?
The team called 911.
Yeah. And the ambulance and emergency crew did come to the school, correct?
Yes.
Nothing further, Your Honor.
3734. Can you redirect?
Yes, Your Honor.
Allow me to reset the clock then real quick. Okay, so 33. Okay. And whenever you start talking, I'll start the timer.
Aubrey, do you remember opposing counsel asking you about some statements Rory made to you while you were running Burma Road?
Yes.
What were those statements?
That she was tired, or that she was I forgot exactly what I said, but that she wasn't feeling all right. She was feeling funny, had chest pain, things like that.
Did her physical experience, her physical appearance match how she was telling you she was feeling?
Yes.
When you were running that Burma Road drill and eventually the slide tackling drill, did it look like Rory needed a break?
Absolutely.
Did it look like Rory needed some water?
Yes.
Did it look like Rory needed some shade?
Yes.
Thank you. We have no further questions for this witness, Your Honor.
3250. Okay. You can call your next witness or read something into the record, whatever you'd like to do, or you can rest.
Yes, Your Honor. At this time, we would like to read brief portions of Dr. Reagan's expert testimony, Exhibit 15, onto the record, Your Honor.
Excellent. Whenever you start, I'll start the timer.
My second chair is going to put this portion up on the screen for our reference.
Sounds good.
Based on all the above, it is my opinion with a reasonable degree of medical certainty that Rory Street died as a result of heat exhaustion and or heat stroke on September 8th, 2018. It is also my opinion within a reasonable degree of medical certainty that Rory Street's death was not a result of cocaine use. First, even if there was cocaine use on the day in question, there is no indication that Rory Street was a habitual user of cocaine, as indicated in the autopsy report by the fact that there was no irritation of the throat. Drug tests for cocaine typically have a lower cutoff level between 5 and 150 nanograms per milliliter, with 5 being very low and 150 being very high. The amount of cocaine found in Rory Street's system was only 60 nanograms per milliliter, which is a finding consistent with the ingestion only of a nominal amount of cocaine, or that there was a great deal of time between ingestion and testing. And with that, Your Honor, we have no further testimony. We rest our case in chief.
Okay. 3150 remaining. All right, defense. Let me set your timer. We can move on. Hold on. You've got 3734. Any motions before we move to your case in chief?
Yes, Your Honor.
Go ahead.
At this time, defense moves pursuant to Federal Rule of Civil Procedure, Rule 50, for a judgment as a matter of law. Your Honor, there's been no legally sufficient evidentiary basis for you as the finder of fact to conclude that the plaintiff has met the burden of proof here today. In fact, Your Honor, what we've heard is that there's been actually no breach of duty of care on behalf of Coach Taylor. Yes, they were at practice, but you heard from opposing counsel's own witness that it was common for those members of that community to practice in that weather. You heard that Coach Taylor was not made aware of any time in which the decedent needed water, a break, or any shade. Well, you were made aware of the fact that the decedent did in fact have cocaine in her system. And that cocaine was the proximate cause of her death, not any sort of drill that Coach Taylor ran. For that reason, I ask you to find it for a judgment as a matter of law in favor of the defense.
I'm going to deny the motion. I believe there's evidence in the record to support
Yes,
so you've got 3643. You can call your first witness or begin your case in chief however you'd like to.
Yes, Your Honor, if I may take this time first to address the cross-examination of
Absolutely.
Jordan Street. Permission for my co-counsel to show her screen as well to read the relevant portion.
We don't need to ask permission for that.
Thank you, Your Honor.
Absolutely.
Good afternoon, Ms. Light.
Good afternoon.
Do you have the deposition of Ms. Jordan Street with you?
I do. Yes, it's in front of me.
If you could please turn to page 3, starting with line 1.
Okay.
Question 1. Were you there at practice that day?
No, I was at work.
So do you have any information or knowledge about what happened that day?
No, other than what I've heard from others about what happened, but I didn't see it.
Turning to page 4, line 4. Was Rory good?
Oh, Rory was a superb athlete. She had gotten several scholarship offers from Division I programs to play soccer in college. Southern Methodist University, Dallas Baptist University, Austin College, and the University of Texas at Dallas. They had all offered her a scholarship. It was so exciting to think about being able to watch her play at the top level in college against some of the best in the country. Plus, she would have gotten a great education. She had a bright future, and I was excited to see it all play out.
Turning to page 5, question 12. Did you push Rory to be an athlete?
I don't know if I'd use the word push, but I encouraged Rory to work hard at sports and at everything else in her life. I taught Rory to never show weakness and to never complain. I wanted her to be tough, to play through the pain, because that's what makes a champion. Rory was tough because I made her tough.
Did you ever hold Rory back in school?
We did, just 1 year. We held her back in the 7th grade so that she could get bigger and faster, which we thought would give her an advantage in high school playing against the younger kids. I know it sounds a bit crazy, but it's actually pretty common now. College is expensive, and we wanted to give Rory the best chance we could at getting a scholarship. Hell, Rory might have been good enough to go pro. I certainly saw that possibility and encouraged Rory to keep that option open.
You know, I apologize for the vulgar language. I should have warned you beforehand. Turning
I can blanch that.
to page 6, line 4. Did you have to stay on top of Rory to make sure she was practicing and keeping up with exercising?
Not any more than any other parent of a teenager. Rory sometimes wanted to goof off instead of following Coach Taylor's non-practice exercise routines, and I would have to remind her of what soccer means for college and maybe a pro career.
Line 18 on the same page. Was Rory a discipline problem?
No, not any more than other kids that age. I mean, she was a little wild and liked to have fun, but she wasn't some hippie smoking dope behind the school or some party animal who stayed out all night. Rory got in trouble a few times and I got called by the principal a few times, but it was just normal teenager stuff, being late to class, goofing around, or missing some homework assignments. I was confident that she would graduate and go on to college. I know that.
Turning to page 7, line 19. When you were playing soccer at Waco High, did you ever have to run the Burma Road?
Hell yeah, we did. I remember doing that when we were dogging it or if we weren't in the correct position or something. Coach would send us off to run Burma Road. But I'll tell you this, none of my coaches ever made me or any other kid keep doing it when it was obvious that we were exhausted. Discipline is one thing, but that is just dangerous.
Thank you, Your Honor. That concludes the deposition testimony. We have read in for the mother, Ms. Jordan Street.
Okay, 33 minutes even. You can call your next witness or continue reading.
Yes, Your Honor. At this time, I'd like to read from our defense excerpt. I think it's been previously stipulated as admissible.
Okay, whenever you start.
Ms. Light, if you could please put the exhibit on the screen. And I'll begin to read the highlighted portion. Spencer London, Toxicology Associates, LLC. Dear Mr. Ducksworth, this letter is intended to serve as my expert report in the above referenced matter. Page 2. Cocaine use can lead to the following symptoms. And among this list, nausea and vomiting, raised body temperature and blood pressure, and chest pains. Page 3. Dr. McConaughey describes the following symptoms for Rory Street on the day in question. Struggling, unusually pale, feeling funny, complained of chest pain, hands on her hips, breathing heavy, groaning, twitching, and convulsing. Many of these symptoms are consistent with cocaine use. Rory complained of chest pain, feeling funny, which will be related to any number of the symptoms of cocaine use, groaning, which could be related to nausea, and convulsing or twitching on the ground. All these symptoms are consistent with cocaine use. Additionally, the autopsy report in this case indicates that Rory Street's heart showed signs of myocarditis, which is an inflammation or swelling of the heart muscle. Myocarditis is one of the physical symptoms associated with cocaine use, which means this finding is also consistent with cocaine use. It is true that the amount of cocaine found in Rory Street's system was nominal, only 60 nanograms per milliliter. However, Rory Street's blood was drawn long after her death and potentially even longer after Rory actually ingested the cocaine. Therefore, this test may not represent the actual amount of cocaine that was in Rory Street's blood at the time the incident or earlier in that day. And it is possible that the amount of cocaine in the system was actually much higher throughout the course of that day leading up to practice. All right, that concludes the expert testimony. Thank you, Ms. Light.
3048, you can call your next witness.
Yes, Your Honor. At this time, we'd like to call the defendant, Coach Taylor.
Ms. Taylor. Whenever you're ready, 3048.
Good afternoon, Coach Taylor. We've had a chance to meet and get to know one another, but if you could please introduce yourself to the judge.
I'm Reese Taylor.
Coach Taylor, why are you here today?
Well, I'm here unfortunately because of Rory's death on the soccer field.
Now, I want to talk in detail about that incident, but before we do, let's let the judge learn a little more about you. Where are you from, Coach Taylor?
Right here in Waco. I've lived here my whole life aside from college.
Where'd you go to college?
Texas A&M. I studied physical education.
Did you ultimately graduate?
Yes, yes.
And what'd you do after you graduated?
I started coaching sports, girls sports, and at high school level, and I teach health.
Now, is coaching high school sports something you always wanted to do?
Always. It's always been my passion. I loved playing sports when I was young. I always wanted to coach.
And where are you coaching now?
At Waco High School, I coached varsity girls soccer.
Now, for about how long have you been coaching?
Altogether, probably more than 25 years. It's a little embarrassing to say it's been that long, but and at Waco High, I've been there for 6 years.
And over the course of you being a coach, what have been some of your responsibilities?
Well, obviously, just helping the girls understand the game, know the best techniques, run drills, plays, things like that. But I also look out for, the safety and health to the extent that I can as coach of the girls.
Now, is coaching an easy job?
No, not always. It can be difficult. I mean, they're high school girls, right? So they don't always want to listen, but it's my passion and it's what I love to do.
And are there any things that you do to try to make yourself a better coach?
Yeah, I attend seminars, clinics, things like that around the state to get tips and techniques, and I want to learn what other coaches are doing.
Now, I want to shift your attention to the events that happened on September 7th, 2018. And I know you lost one of your players that day, so if you need to take a moment to gather your composure, feel free to do so. But what was that day like?
Well, it started like any other practice, and the girls come to practice right when school gets out, so around 3:30 or so. And I was having the girls scrimmage.
And was it typical for you to hold your practice at 3 o'clock after school?
Yeah, yes.
Now, did you make sure your players had the resources they would need during practice?
Yeah, I mean, if anyone knows, Waco at 3 p.m. in September, it is hot. So there is water on the side of the field for the girls.
Now, what was your plan for practice on September 7th?
Just to scrimmage mostly that day.
Now, you do coach at Waco High School in Waco, Texas, correct?
That's correct.
Would most of your players be familiar with the summer heat in Waco?
Yes, yeah, absolutely.
Now, as this day was developing, what did you begin to notice about Rory?
She just really wasn't taking practice seriously. I noticed at first that she wasn't performing as well as she usually does. And I understand that, sometimes the girls just have off days, but then she really wasn't listening to my critiques and my pointers. And that frustrated me because she's usually very respectful. And so, this goofing off, sort of not taking practice seriously is what I noticed in her.
And were her soccer skills suffering as well?
Yeah, exactly. I mean, that's what I first noticed, that, she was missing passes and shots. And so, and then she wasn't listening to me.
And once you saw that taking place, what'd you do next?
I had her run the Burma Road drill. It's sort of a typical, when the girls are acting out or doing something they're not supposed to be, why don't you go run Burma Road?
And when you sent Rory to go run Burma Road, was that something that was common to your practices?
Definitely. I think I sent at least one other girl that day to run Burma Road. So it was sort of the girls knew if they were acting out, probably Burma Road would be what would happen.
And have you ever seen any of your players pass out, lose consciousness, or even pass away from running on Burma Road?
Absolutely not. I mean, it's not a cakewalk. They don't love it, but that's sort of the point, but certainly nothing serious.
Now, what happened after you sent the decedent to Burma Road?
Well, I could see her. She was sort of at the other end of the field. So I wasn't, I was still working with the other girls, but I could tell from far away that she wasn't taking Burma Road seriously now, that she was kind of goofing off, messing around. And so, I needed her to sort of, stop acting like that. And I decided to run another drill with her.
And what was this other drill you ran?
So it's something called a slide tackle. I had some of the other girls on the team, or the rest of the team, line up and sort of play opposition to Rory. She was dribbling the ball, and the other girls would attempt to slide tackle her.
And up to this point in practice, did Rory ever ask you for a break?
No,
Did she ever ask you for water?
no,
Did she ever ask you to take her to any sort of shade?
no, she didn't.
So as this drill is happening, or as this drill is taking place, what happened at the end?
Well, I mean, tragically, Rory, she collapsed, and ultimately she passed away.
And at that time, did you know what caused her to collapse?
No, I mean, she had been doing the drill. I think at least 14 or 15 girls had come at her, and she was continuing on with the drill. I found out later that she had cocaine in her system.
Now, Your Honor, at this time, I'd like to revisit what we discussed in motions in limine, allowing the use of the autopsy and toxicology report.
Okay, so you're at 2340. Go ahead.
Oh.
Yeah, sorry, go ahead.
Thank you, Your Honor. Ms. Light, if we could please.
Well, hold on. I'm just confused as to what's happening here. Are you anticipating an objection on these? Are you?
I'm not completely sure because we talked about it pre-trial, Your Honor, and I know you said you would revisit allowing it to be admitted into evidence.
Objection when you try to get these admitted. They're not pre-admitted, right?
Exactly, Your Honor. They're just authentic.
Before you publish them, let's make sure that we lay the foundation, to get them admitted or request that they be admitted, and then proceed like that.
Yes, Your Honor. That's what I'm attempting to do. I just want to be able to ask her to speak on what the exhibits are, Your Honor.
Sure, absolutely. And time's still paused. I'll let her pull them up, and then when you start talking, I'll time back in.
Thank you, Your Honor. Now, Coach Taylor, are you able to see exhibit 14 and 15? Do you have that?
Let me pull that up. 14 and 15. Yes.
If you can look at 14 and 15, who created exhibit 14?
The McLennan County Medical Examiner's Office.
And if you look at exhibit 15, who created exhibit 15?
Also the McLennan County Medical Examiner's Office.
Now at this time, defense offers what's been previously marked as exhibit 14 and 15 in the evidence.
Okay.
Your Honor, we do just have an issue with exhibit 15. We believe exhibit 15, the toxicology report, is hearsay. We don't believe it's a public record.
Okay, so 14, though, I'm fine to admit without objection.
Yes, Your Honor.
Okay, so 14's admitted. With respect to 15, let's just very quickly hear that argument one more time, Mr. Okola.
Your Honor, we don't believe this suffices as a public record. We believe there are circumstances that indicate the trustworthiness of this document in the sense of when it was conducted, what specifically it was conducted for. This is an entire toxicology report, and it seems as though they only tested for alcohol, THC, and cocaine. It's not even a full panel, Your Honor. So there are circumstances that we believe indicate the lack of trustworthiness of this document, and pursuant to Rule 803.8, that must be met.
Mr. Littlejohn?
Yes, Your Honor, we've previously agreed that this document is authentic, which means it is what it purports to be, which means it is produced by the medical examiner's office. I find it interesting that the lack of trustworthiness exists here on exhibit 15, but opposing counsel doesn't see a lack of trustworthiness on a record made by the same office around the same time period in exhibit 14. Both of them are public records, and both of them are admissible because of Federal Rule of Evidence 808.
I'm going to overrule the objection, and I'm going to allow exhibit 15 to come into evidence. Both of them, you have 23:04. Time will start when you get back to your examination.
Ms. Light, if we can, thank you, Your Honor. Ms. Light, if we can, please share the exhibit on the screen. Thank you, Ms. Light. Coach, can you see that exhibit on your screen?
Yes.
And what is the title of this exhibit?
Toxicology Report.
And I want to turn your attention to where it says toxicology about midway through the screen here. If you could, please, can you read that third row? And Ms. Light, can you highlight as she reads that row?
Under specimen, it says blood. Under drug, it says cocaine. Under positive or negative, it says positive. And under amount, it says 60 ng per ml.
Thank you. And Ms. Light, can we please turn? Ms. Light, we can please see exhibit 14.
Just 1 second, I apologize.
Oh, you're fine. Take your time, Ms. Light. Coach, are you able to see this exhibit on your screen?
Yes.
And what is the title of this exhibit?
Autopsy Report.
And when was this autopsy report dated?
9/8/18, September 8th, 2018.
Thank you. Now, Ms. Light, can we turn to the second page of this exhibit, please? Coach, if you can, please, can you read the sentence underneath opinion? And Ms. Light, can you highlight that sentence for us, please?
While the cause of death is listed above, we are unable to determine the cause of the sudden cardiac death that took place in this case.
Thank you. Ms. Light, we can pull down exhibit 14 and 15. Now, Coach, at practice that day, were you aware that the decedent had cocaine metabolizing in her system?
Absolutely not. If I had known something like that, things might have been different.
Nothing further, Your Honor.
$20.02 remaining.
Thank you, Your Honor.
Okay. Let's see. Okay, cross 3150 whenever you start.
Thank you, Your Honor. Good afternoon, Coach Taylor.
Hi.
I want to start off by seeing if we can agree on some pretty, I think, basic things here. Now, we can agree that it's your job to look out for the best interests of your students.
Yes.
That includes your students' health.
Yes.
We can agree that you shouldn't ignore a student who's in distress.
Correct.
We can agree it'd be wrong to punish a sick child.
Yes.
We can agree if a child came and they had the flu, you shouldn't run them.
That's right. Yeah.
It's wrong to expose children to unnecessary risk,
Yes.
unnecessary dangers.
Yes.
I want to talk about the dangers you exposed Rory to back in 2018. Now, you understand that it can get pretty hot here in Waco, right?
Yes, absolutely.
I mean, you've been coaching here for over 6 years, so you know that it can get often over 100 degrees.
Yes.
Now, that's pretty hot for a soccer practice, right?
Yes. We like to condition the girls the same conditions that a lot of their games will be in. It's the Texas heat.
It's so important and so extremely hot that you all talk about this as coaches, right?
Mm-hmm. Yes.
There's a Texas Association of High School Soccer Coaches, right?
Right.
You guys meet every year.
Right.
When you guys meet, you discuss best practices.
Yeah, it's kind of more of an exchange of tips and tricks and things like that. But
You exchange best practices.
sure, yes.
You attended a meeting 3 months before this incident, right?
I think that it was in June. So yes.
In that meeting, you learned of the dangers of exposing students to heat.
Yes.
You know, it's important to give students frequent breaks depending on how hot it is.
Yes.
You know, the hotter it gets, the more breaks you should give students.
Yes.
The hotter it is, the shorter the practice.
Yes.
And we know that heat can cause some serious damage to students, right?
Right.
After all, that's why the association, you all play your games in the evening.
Games aren't always in the evenings.
Predominantly games in the evening for when it's cooler outside, right?
Yes.
Now, I want to talk about how you as a coach prepare or prevent your students from being hurt or injured in extreme heat. Now, as a coach, you provide water.
Yes.
You provide that water by way of taking a break sometimes.
Yes. Yeah. It's just there. And if the girls need a break, they go and get the water themselves.
You don't provide any shade.
No.
You don't provide any Gatorade,
No.
but you could have.
Yes.
You could have provided that on September 7th of 2018,
Yes.
but you didn't.
No.
You understand that having shade is important in extreme heat, right?
It can be. Yes.
That's what you learned from that Texas Association of High School Soccer Coaches.
Objection, Your Honor.
Basis?
This is hearsay at this point. She's attempting to ask her questions about something she learned from what I believe is a PowerPoint that has not yet been admitted in evidence.
Your Honor,
He's asking, what did she learn? How is that an out-of-court statement?
Because she would have had to have read or learned the statement before she came into court here today. It was from a PowerPoint that she learned from that conference when the conference took place.
You can respond to the objection, but I think you can tell where I'm going with this.
Your Honor, I don't believe any statement has been elicited. Furthermore, Your Honor, the statement was already on the record. I'm asking her now where she got that from.
That's right. I mean, I don't think there's anything about this that is hearsay. So I'm going to overrule that objection. If we get into hearsay territory, feel free to raise the objection again. 28 when you start again.
You learned it's important to have shade for the students in that extreme heat.
Yes.
Now, I want to talk more about some of those precautions that you take. Now, you intentionally have your players practice in the afternoon.
Yes.
That's a decision you make.
Well, they're at school all day, so it has to be after school.
You decide to have practice in the early afternoon.
Yes. Yeah.
Now, that practice usually starts around 3 p.m., right?
That's right.
And at 3 p.m. on September 7th, that's when the heat began to rise.
Yes, it's hot at 3.
Now, you intentionally have your students practice in the heat because you believe it toughens them up.
It's not that it toughens them up. Yes, a lot of times games are hot, and that's for conditioning. And that's the point of it.
I want to make this perfectly clear. You intentionally have your students practice in the afternoon when it's hot outside because it toughens them up.
But it's not only because it's so hot, right? I mean, they don't want to leave school and come back. It's also just the most convenient time to have practice. But yes, I think that it's a good idea to be practicing in similar conditions to how the games will be.
You want to make sure that they can hold up in the heat.
Exactly.
Now, I want to talk about the impact that all of these circumstances had on Rory on September 7th. Now, during that practice, you noticed that Rory started acting different.
Yes, in that she's usually very responsive to my critiques, and she's one of my star players. She's a great athlete, and she wasn't acting like herself in that regard on the 7th.
To use your words, she was acting different.
Yeah, that's what I just said. Yes.
She's typically your best player, right?
Correct. Yeah.
She was missing passes,
Yes.
missing wide open shots.
Yes.
You noticed that Rory wasn't acting normal.
Right. I mean, she has off days. Everyone has, all the girls have off days sometimes.
You could sense something was up with Rory.
To the extent that she wasn't listening to me and she was goofing off. Yeah, something was off.
I want to talk about what you did when you noticed there was something different about Rory. You didn't ask if Rory needed a break.
No, nothing about how she was different indicated to me that she was tired or it wasn't different in that sort of way.
Well, to use your words, she was dogging it out there, right?
Right. She was goofing off. She was not playing well. It didn't seem like she was worn out. She was just kind of, not making passes and things.
When you noticed she was dogging it, you didn't ask her if she wanted a break.
No.
You didn't ask if she was okay.
No.
You didn't ask if she wanted water.
No.
You didn't ask if she needed to go and see the athletic trainer.
No.
You decided to discipline Rory.
Correct.
So you sent her to Burma run.
Correct.
And you had her run until you told her to stop.
Correct.
And while she was running Burma Road, you weren't bothered. You were over there running practice with the scrimmage, right?
Correct.
And then you looked back over and you thought, Rory's still dogging it.
Correct.
So you wanted to discipline her more.
Yes.
Now this discipline, you had her do a slide tackling drill, right?
That's right.
This is something you had never ran before.
The girls practice slide tackles all the time. This particular drill, no, I hadn't done before.
This particular drill had never been tested by you.
No.
You remember those guidelines we were talking about earlier from the National Texas Soccer Coaches Association, right?
Right.
In there, they talk about slide tackling, right?
Maybe.
Is your testimony they did not talk about slide tackling?
I don't recall that.
I'm going to object again.
Okay, go ahead.
Opposing counsel is yet referencing some high school athletic association guidelines. Those guidelines are out of court statements being offering to prove the truth of the matter they assert and talking about these slide tackles. Opposing counsel would have to admit that PowerPoint presentation of those guidelines before us or lay the foundation for how she would be aware of them and defeat hearsay.
Okay, so Mr. Littlejohn, she's struggling to answer the question because the question was, did you learn at that conference about whatever they're called, whatever the kind of tackle it's called. So he's asking her about her experiences. Insofar as we start going into the content of the slides, I agree. I mean, it may be useful to try to get those before evidence, but if you want to just talk in the abstract about a conference, I mean, she can tell you her experiences, and that's not an out-of-court statement to say what she experienced and learned at that conference. So I'm going to overrule that objection until the time that he attempts to either read those statements in without the proper predicate laid, but until we get there, it's not hearsay, okay?
Yes, Your Honor.
Okay, so overrule. Give me 1 second to get the timer back up. So you're at 23:16, Mr. Okolo, and just be aware you could veer into hearsay territory, and I'm going to allow him to raise that objection again.
Yes, sir.
Okay. Again.
Now, Coach Taylor, you know that slide tackling should only be done when necessary.
Yes, in a game. In a game, of course, you only do it when necessary, but I want to make sure my girls are prepared for that event in the game. And so to say you shouldn't practice them because they should only be done when necessary, no, I don't agree with that at all.
But Coach Taylor, on September 7th, you didn't run that drill because you were preparing those girls for a game.
I mean, it's twofold, right? Yes, I was disciplining Rory, but she's also my star player. So it also was the purpose of practicing slide tackles, having my other players try to get the ball from Rory, who was my best player, and let Rory practice holding on to the ball during it. So no, it wasn't purely punitive.
Coach Taylor, you wanted to punish Rory.
Yes, I was disciplining Rory.
And you picked this drill because it involved a lot of physical contact.
It was challenging, yes.
You picked this drill because it involved a lot of physical contact.
Well, slide tackles involve a lot of physical contact, and that's why it's so important to practice them. So again, twofold.
On September 7th, 2018, you picked that drill specifically because it involves a lot of physical contact.
Your Honor, ask and answer.
Your Honor, the witness is evading the question.
No, I'm going to sustain that objection. You've asked that question now 3 times, so let's move on.
You wanted to make sure Rory was getting your point when you ran that drill.
I'm sorry, what? Getting my what?
You wanted to make sure Rory was getting your point when you ran that drill.
Yes, I was disciplining Rory.
So you had all the students line up,
Yes.
and they slide tackle one after another.
Yes.
And when she struggled, you would make Rory get up and do it again.
Yes, I think about 14 or 15 girls slide tackled her.
When she struggled, you would make her get up and do it again.
I don't recall ever having to make her get up. She continued with the drill as I had explained it.
Under your direction, she got back up and did it again.
I don't recall her ever having fallen down necessarily.
It's your testimony that she didn't struggle at all through this drill.
No, she was struggling. It was a tough and challenging drill, but nowhere did her struggling ever rise to the level that I thought she needed medical attention.
And the point was for her to struggle.
Yes, it was a challenging, physically challenging drill for a top athlete.
And then she collapsed on that 15th time.
Yes, that was absolutely tragic.
Do you think she got your point?
Objection, Your Honor.
Basis?
Speculation.
I'm asking her thoughts and feelings, Your Honor. It's not speculation. Do you think she got the point? That's her thoughts and feelings.
If I may, Your Honor.
Got the benefit of the question. I'm going to go ahead and sustain the objection. She can't know what she was thinking at the time. Move on to a different question. I'll sustain that objection.
It wasn't until Rory collapsed and couldn't get back up that you stopped practice.
Yes, obviously I stopped practice at that
It
point.
wasn't until she collapsed and got back up that you went and checked on her.
She didn't get back up.
So you went and checked on her.
I don't recall exactly what I did after that happened.
It wasn't until she collapsed that you called the athletic trainer to come over and check on her well-being.
I guess that's right.
Thank you. We have no further questions, Your Honor.
1948. Okay, any redirect of this witness?
Yes, Your Honor.
Okay, give me 1 second to reset your clock. You have 20 minutes and 2 seconds. Whenever you start talking, I'll start the time.
Thank you, Your Honor. Coach Taylor, how long had you been coaching?
About 26 years, I think.
And did you have to coach through the summer as well?
Yes.
And did you have to create drills for your players to use?
Yes, it's always a dynamic situation.
And did you ever have to discipline your players with conditioning?
Absolutely.
And has there ever been any time that one of your players collapsed, lost consciousness, or lost their life or at one of your practices?
No, never. This was, a shocking tragedy for everyone.
No further questions, Your Honor.
No recross, Your Honor.
Okay, can this witness be excused?
Thank you, Your Honor.
1923 remaining defendant, just so you're tracking.
Yes, Your Honor. At this time, I would like to allow my co-counsel to join me in reading the deposition testimony of the trainer for the Waco soccer team, Jesse Mayweather.
Whenever you start, I'll start the timer.
Thank you. Good afternoon, Ms. Light.
Good afternoon.
Do you have the deposition of Ms. Jesse Mayweather in front of you, or Jess Mayweather in front of you?
I do, yes.
I want to turn your attention to page 2 Question 6. Good morning. Would you please state your name for the record?
Hello there. My name is Jess Merriweather.
And what is your job at Waco High?
I am an athletic trainer and I also teach health.
And what is the job of an athletic trainer at a high school?
We have various teams and activities at the school that involve some level of physical activity and competition. Everything from football to soccer to volleyball to cheerleading and drill team. As a trainer, I work with the students that participate in those activities to keep them healthy and in shape and to treat any injuries that they have.
Do you attend practice?
Yes, depending on what time of year it is, it may be football or soccer or something else, but there is always a trainer at any official practice for our various athletic teams.
Are you familiar with Coach Reese Taylor?
I am.
Who is Coach Taylor?
Coach Taylor is the varsity soccer coach at Waco High.
Do you know who, I'm turning your attention to line 18. Do you know who Rory Street was?
Yeah, I knew Rory. Very sad what happened.
How did you know Rory?
Well, she was a varsity soccer player, so I worked with her as a trainer for the varsity soccer team, just like any other player.
Had you ever heard anything, or turning your attention to page 5, line 3. Had you ever heard anything about Rory doing drugs, or did you ever see anything that would lead you to believe Rory did drugs?
On several occasions, I saw Rory lingering outside with the smokers at lunch. There are a bunch of kids in that group of smokers and vapors that have a reputation for using drugs. So it wouldn't surprise me if Rory did too.
Objection, Your Honor, for relevance. To that last portion, it wouldn't surprise me if Rory did too.
Okay. Explain the objection.
Your Honor, her thoughts and feelings about whether she believes Rory did drugs are not probative in today's case and having us decide whether or not Coach Taylor acted reasonably on September 7th of 2018.
Your response?
Your Honor, defense case in chief rests on the fact that Rory actually was using cocaine, and cocaine was in fact the cause of her death. So the testimony about how it could have been Rory actually using cocaine while at school is highly relevant to our case.
Brief rebuttal.
Your Honor, her feelings, if she believes Rory did drugs or not, is not relevant. We have a toxicology report. What she believes is not probative.
Okay. I think it's highly relevant, right, given that one of the questions here is notice, insofar as I think another question is whether or not the coaching staff had notice of any potential drug use. So I do think it's, given the low standard for relevance, I think it's admissible, and so I'm going to overrule the objection. 1721, when you begin again.
Ms. Light, can you start at line 9 and keep reading?
So it wouldn't surprise me if Rory did too. Drugs are a problem at every level of sports, from high school through the pros. And it isn't just steroids. In fact, every year I give a lecture at the local Kiwanis Club chapter meeting about the negative effects of drug abuse on young athletes. Several of our players came to hear that speech, but Rory never came.
Line 20. You said that you worked with Rory as an athletic trainer. Did you interact with Rory in any other capacity?
Rory was in my health class that year, so I would see her 3 days out of every week in health class.
Turning to page 7, line 8. Jess, were you familiar with Rory's handwriting?
I mean, I had certainly seen her handwriting before on tests and homework that she would turn in. So I was as familiar with her handwriting as any other student that I had in class.
Based on the familiarity with Rory Street's handwriting, does the handwriting on Exhibit 12 appear to be Rory Street's handwriting? And Your Honor, at this time, I'd like to admit Exhibit 12 into evidence, or I'd like to offer Exhibit 12 into evidence.
Your Honor, we would object to hearsay again, and we believe there's authenticity issues. I may be heard on that.
Sure.
Not a court statement being used to prove the truth of the matter asserted, so it is hearsay. On the authenticity issue, Your Honor, we understand that 901 allows a witness to identify the authenticity by identifying handwriting, but we have a unique situation here, Your Honor. If I may proffer.
Sure.
This document was signed RC, just the initials RC. We were provided a list of individuals in that class at that time. There are 2 individuals in that class who had those same initials, Your Honor. The witness was never asked if she could identify the handwriting of that other individual. And because we don't know whose handwriting it actually was or who actually signed RC, there's an authenticity issue.
Might be heard, Your Honor.
Sure.
The initials are RS. There are two people in that classroom, initials RS, Rory Street, and then another person. Now, whether or not we have the other person's handwriting is, again, a weight, not admissibility argument. What we've just heard is that she was familiar with the handwriting and that she could identify the handwriting pursuant to Federal Rule of Evidence, Rule 901B2.
I'm going to agree with that. That's totally a weight issue. The fact that he didn't take the extra step to negate another possibility, that purely goes to weight, not admissibility. Insofar as you've said, he's met the prerequisite of obtaining the testimony that this witness indeed did think that it was the decedent's handwriting. So overruled 1607 when you start reading again, okay? And it's admitted, sorry, in case my ruling wasn't clear. So you're free to publish.
Thank you, Your Honor. Ms. Light, if you could, please, can you put Exhibit 12 or share Exhibit 12? Ms. Light, can you read Exhibit 12 for us, please?
I really like the snow you sold me yesterday. Can I buy some more? Let me know in health class. RS.
Thank you, Ms. Light. Turning your attention to page 8, line 18. At any time, did you see Rory stumbling, faltering, or slowing down in any way that would have indicated she was in trouble?
No, not at all.
And I just want to go back to something on page 6 as well. At line 11, or line 15, where did you find this note exactly?
It was just a couple of feet away from Rory's desk in a nearby aisle.
And when did you find this note?
It was a week before Rory's death.
I want you to go to page 9, line 1. Did Rory ever say anything to you about feeling bad that day?
Nope, never said anything to me. And here is the thing. I'm there to take care of those players and they know it. I'm kind of a combination trainer and a guardian to the team. So they trust me and I trust them to tell me if something is wrong or if they're hurting. Rory didn't say a word and she would have. Rory was a tough kid, but she knew.
That's speculation. Saying Rory would have said something if she felt a kind of way is speculation.
Response?
Yes, Your Honor. This is the trainer for the athletic program that's familiar with the decedent as a player and is familiar with the decedent's disposition to let someone know if she needs help or not, or if she's in trouble or not. She's making a lay witness testimony based on her rational perception related to the decedent.
Okay, I will instruct the jurors as follows. The testimony that you're about to hear is limited, to the trainer's capacity to observe things. She, of course, at no time resided in the head of the decedent. She's not omniscient either. So this testimony is only given for the purpose of establishing what her expectations would have been based on her previous observations of the decedent. The time you have now is 14:33. When you start reading again, I'll start the time.
And it's like, can you begin on line 6, starting with Rory?
Rory didn't say a word, and she would have. Rory was a tough kid, but she knew her limits and would let me or coach know when she needed water.
Line 9. Are players allowed to get water when they want it?
Objection, sorry.
Just for the record, Your Honor, I have to note my continuing objection to the rest of that document as well as speculation. Saying that Rory knew her limits and Rory knew when to stop is speculation.
Okay. That's fine. I'm going to overrule that objection. And, just to be safe for our record, I'll again say what I said. She's only talking to her experiences and her impressions of that student. Of course, the testimony should not be taken as any sort of, omniscient being observing what the decedent actually thought or felt at the time. So with that, 14:18, when you begin reading again.
It's like looking at page 9, line 9. Are players allowed to get water when they want it?
Yes, all they have to do is ask, even if we're not on a water break.
Thank you. Nothing further, Your Honor.
10:05. And do you rest?
Yes, Your Honor. With that, the defense rests the case in chief.
Okay, so we're ready for closings now.
Your Honor, if we can just have a brief 1 to 2 minute recess just so I can gather my notes here.
Sure. I'll give you a 5-minute recess. Scoring judges, let's be back at 54. If you need to get up to go to the bathroom, like I said, please turn your camera on. That way I can see that you're gone. I can make sure that you're all in the room before we start hearing those closings. Okay. Okay, so you had 14:05 remaining. I'll start the time when you start your motion, okay? Go ahead.
Your Honor, it's also my understanding that motion time during motions doesn't count against the time, is my understanding. I may be wrong.
I verified that earlier with the rules today. It's only objections that don't count for time. Your substantive motions, of course, count for the time.
Okay, well, with that being said, I'd just like to renew my Rule 50 for judgment as a matter of law, Your Honor.
And I'm going to again deny that motion, but I understand why you want to do that for the purpose of your record. That leaves you with 14 minutes even. Okay. So 1948 remaining for plaintiff and 14 minutes even remaining for defendant. Let me set the timer for 1948. And plaintiff, when you begin talking, I will begin the timer.
May it please the court and opposing counsel. The defendant knew that there was something different about Rory at soccer practice on September 7th of 2018. Out of nowhere, this defendant's star player who had never had any issues started to struggle. She started to be fatigued. She was tired. She was gasping for air, folks. She could not breathe. But instead of asking if she needed some water, asking if she needed some help, asking if something was wrong, the defendant punished, disciplined, pushed and pushed and pushed until she ran Rory into the ground. That's what this case is all about. Now, it's important to know that high school teachers, high school coaches, they're dealing with a unique population of our community. They're dealing with teenagers who have hormones, teenagers who make bad decisions, teenagers who might not know their limits. It's the coach's responsibility. It's the teacher's responsibility to be that one adult in the room, to make sure the students are looking out for themselves, to make sure they're not pushing themselves too hard, to make sure they're making those right decisions. It's the adult's responsibility. And we know that the defendant understood that responsibility. We know the defendant understood that it was her responsibility to look out for the safety and the well-being of the individual she coached. I asked her that on cross-examination. Furthermore, she told us about the course of today's trial that time and time again, year after year, she would attend coaches meetings. In these coaches meetings, they would talk about best practices, talk about what they should do to make sure that students are okay under the heat, to make sure that they're being safe. She told us that she knew as the heat began to rise, they needed to offer more breaks. That as the heat began to rise, they needed to make sure they had water. That as the heat began to rise, they needed to make sure they provided shade and that practice was shorter than normal. That was the defendant's responsibility. We know that the defendant didn't uphold her responsibility in today's case because Rory died. We know that because we took a look at that practice on September 7th. We looked and we saw what happened. We saw the defendant trying to punish Rory, trying to push Rory. The defendant knew was something different. The defendant knew that their star player all of a sudden was missing passes, couldn't make wide open shots. Something was different. Something just seemed off. But she didn't ask if she was going to be okay. Didn't call the athletic trainer to make sure she'd be fine. No, she just continued to push and push and push. She did it because she wanted to make them tough. You heard her today. She said that I intentionally practice in the afternoon under that heat to toughen them up. I want to make sure they're ready to go for the season. The tougher they are, the better. Now, we knew that Rory was a pretty tough player. Rory had been playing soccer since she was 4 years old, raised by her parents. You heard her mom talk today that she made her tough. And that's why Rory was tough. You heard from Aubrey that Rory was that kind of student that kind of hid what was going on sometimes. That it was obvious that Rory was going and suffering and having trouble breathing and having chest pains, but she just didn't say anything. She didn't say anything because she was supposed to be tough. She was trying to push herself to that limit. She was doing what teenagers did, trying to hold back, trying to hide those emotions, but it's all over your face. We heard time and time again that Rory was saying, I feel bad. My chest hurts. We heard she never told that to Coach Taylor. But I asked Aubrey, when she told you that, was it obvious in her appearance that she felt that way? She said yes. As she was running and looking tired, it was obvious that there was something wrong with Rory. And yet again, the defendant did nothing. Nothing at all to make sure Rory was okay. We heard that as a result of her doing nothing, Rory suffered heat stroke. She was showing those symptoms that should have let any reasonable person at the time know that Rory was overheating and she could not cool her body down fast enough during practice. It was the coach's responsibility to make sure she was okay. And she failed to uphold that responsibility. Now, of course, that's not the story the defense is putting forward today. They don't want you to look at the actual symptoms that Rory was facing. They just want you to look at this toxicology report and say that Rory had drugs and cocaine in her system, and that could be the only reason why Rory suffered that day. But let's take that as truth. Your Honor, assume that, Rory had cocaine in her system. Assume that she was suffering from maybe a possible drug overdose. But is it realistic to believe that all of a sudden Rory just collapsed? The defense wants you to believe that she was so hung up on drugs, so intoxicated that all of a sudden she just fell and collapsed. That from the time she was being okay to the time she started to collapse and seize, there was nothing in between. No warning signs to show that somehow, some way, Rory wasn't feeling okay. You see, it's not really about the drill, Your Honor. It's not about the specific technique. It's not about Burma Road. We've heard they ran Burma Road for years. That's not an issue. The issue is under the circumstances. In that specific time, was it appropriate for the defendant to continue to push? Was it appropriate for the defendant to punish in that circumstance? And in that circumstance, we see it wasn't. Whether she was suffering from a drug overdose or whether she was suffering from heat exhaustion, Your Honor, Rory was showing signs that she was in distress, that she needed help, she needed a break, she needed water, she needed someone like her coach, that adult in the room, to look out for her well-being, to say, hey, are you okay? If the coach would have just stopped for 10 seconds and asked, Rory, do you need water? Are you okay? Rory could have told her, hey, I'm struggling. I need to take a seat. Please let me go see the athletic trainer, but she didn't. They just want to point the finger at Rory and say it's Rory's fault that she didn't ask for help. It's Rory's fault that she didn't ask for water. That's not how high school works, folks. It's the teacher and the coach's responsibility to make sure they're taking breaks at the right times, to make sure they're getting water at the right times, to make sure they're looking out for the best interest of everyone involved. And Your Honor, we see that never happened today. Never happened once. The coach cared more about making those students tough, pushing them to their limits than about their actual health conditions at that time. The coach just wanted to put a blindfold on all practice, run them till they were so tired that they died of heat exhaustion, Your Honor. The coach didn't care. Because of that lack of care, a mother lost their daughter. A friend lost their best friend. And we lost someone very important to our community. Today, we needed to show you that the defendant did not act like a reasonable person would have done in the situation. A reasonable person seeing that one of their star players was acting different and something was wrong would have asked, are you okay? They would have taken a moment to take a break and stop. They wouldn't have punished, they wouldn't have pushed, and they wouldn't have disciplined. That's all you heard the defendant did today. It's for these reasons that we're asking you, Your Honor, to hold this defendant responsible.
Okay. 11:13 remaining. Okay, Mr. Littlejohn, 14 minutes even. Whenever you start talking, I'll start the timer. Your microphone's off right now. There we go.
Thank you, Your Honor. Ready to proceed, Your Honor?
Yes, sir.
When you ingest a dangerous substance, you risk the deadly consequence. And on September 7th, 2018, as the decedent, Rory Street, was metabolizing cocaine that she recently ingested, she tragically fell victim to the consequences of that deadly cocaine. Your Honor, this story started in September 2018. As the decedent fell prey to the pressure of high school, as she succumbed to the pressure to begin to experiment with cocaine, as she made the decision to not say no to drugs. And as this cocaine was metabolizing in her system, she still chose to continue with her same routine of going out into the Waco sun for soccer practice. And as she got out there on that field, without telling anyone that she was now under the influence of drugs, she began to exert heat and energy all from her body. That's why her performance began to suffer. She begins to miss the soccer ball. She begins to miss passes. She begins to miss shots. And the coach, Coach Taylor, she notices. And because she's not aware that her star soccer player is now taking an illegal substance, she addresses this issue. She tells her soccer player to run some drills. And as these drills are taking place, Coach Taylor, much like the rest of the decedent soccer team, gets shocked when the decedent collapses to the ground. But more shocking than that is that Coach Taylor learns that her star player tragically fell victim to the deadly consequence of ingesting cocaine. Your Honor, that effect of cocaine and what it had on the decedent is why we're here today. Now, as you know, in a few moments, you'll have to answer the questions that we discussed on the verdict form. And you'll have to ask yourself, was Coach Taylor negligent? And was Coach Taylor's negligence the proximate cause of the decedent tragically losing her life? And I want to walk you through the evidence when addressing those questions, Your Honor, because there hasn't been enough presented before you here today to allow you to answer that question in a yes. So let's turn to negligence. The law here in Waco states that negligence is comprised of duty and breach. And a person is negligent when they do not act with the ordinary standard of care that a reasonable person would use in the same or similar circumstances. I want to talk about the duty. Your Honor, that's not even in contention here today. Coach Taylor knows that she's the head coach of her soccer team. She knows that she has to act reasonable, and she knows for the last 26 years she's been coaching how to be a coach. But what opposing counsel argued here today was that Coach Taylor breached that duty. And opposing counsel focused on three different things to try to convince you that that's what happened. You heard about the circumstances around the practice. You heard about the actions during the practice, and you heard about the observations that Coach Taylor had during that practice. I want to talk about those one by one. Look at the circumstances. We know that it was triple-digit temperatures on September 7th of 2018. But this is nothing new to Waco. In fact, Coach told you that all of her players are from Waco, and summer after summer, for the last 26 years, players have been playing soccer in the sun in Texas, and that it's ordinary for them to do so. Opposing counsel tried to make a big deal about there not being tents, and not being Gatorade. But for the last 26 years, players in Waco under coach have been drinking water. Your Honor, time after time, opposing counsel tried to convince you that that was not ordinary. I want to be very clear. That is definitely ordinary. And then opposing counsel mentioned what the coach observed. How Coach Taylor saw the star player who appeared to be exhibiting signs of weakness and fatigue. Your Honor, Coach Taylor is a good coach. Been a coach for the last 26 years who's coached children all ages. And never once has the drills that she's used and the tactics that she's employed ever resulted in any one of her players losing their life. Coach Taylor wants to win. She wants her team to experience success. She wants her players to get trophies. She wants her players to go to college. And if being that kind of coach, if being that invested into your team is a crime, Your Honor, then Coach Taylor's guilty. But she never once tried to harm or hurt or do anything that would affect her players. And then lastly, you heard about this slide tackling drill. And Your Honor, opposing counsel tried to paint this picture of something that was unreasonable under the circumstances. But as we know, slide tackles are common to the game of soccer. And slide tackles are important in the game of soccer. And when you're competing at a high level, like high school soccer, you need to be prepared to perform at that level. Your Honor, you don't see fighter pilots practicing their takeoffs on Love Field Airport. You don't see football players going to practice and never have a contact drill. You have to experience in practice so you can perform well in a game, and that is reasonable. And that's what Coach Taylor did. Now, opposing counsel again also failed to mention to you that they had the burden of proof. And they had to convince to you by the greater weight of all their evidence that they proved that Coach Taylor was negligent. And Your Honor, none of the evidence they presented here today came close to meeting that burden. However, there's a part two of that question. And the question asks, was Coach Taylor's negligence the proximate cause? The law here in Waco states that proximate cause is any cause that flows from the negligence that was reasonably foreseeable. Now, opposing counsel came before you and brought you some expert testimony. And they used that expert testimony in a way to try to convince you that it was this heat exertion and all this heat exhaustion and the drills that led to the descendant tragically losing their life. But Your Honor, on that actual report, there's some key information. The same things that the plaintiff expert points to as causes for heat exhaustion are the same things that are causes under using cocaine. Now, this plaintiff expert doesn't even have a degree in toxicology. This plaintiff expert doesn't even have experience testifying on these kind of matters at trial. So when you ask, did the plaintiff's expert help them meet their burden in showing to you that it's more likely than not that the defendant's drills caused her injury? You should know the answer is no. However, we brought you further evidence to further show you how Coach Taylor didn't cause it. We brought you our own expert, who is a toxicologist, who was able to show you that there was 60 nanograms per milliliter of cocaine in the decedent's system at the time she was had her autopsy done. Your Honor, that's not good for the body. It resulted in myocarditis. Now, and I want to point your attention to what that report says, because it says in the bottom part, Is it true the amount of cocaine found in Rory's, it is true amount of cocaine found in Rory Street's system was nominal, only 60 nanograms per milliliter. However, Rory Street's blood was drawn long after her death and potentially even long after Rory actually ingested the cocaine. So there could have been even more drugs in her system at the time she was in this Waco Sun. And Your Honor, no matter what opposing counsel says about what Coach Taylor should have done and should have been able to see, she would have never known that the decedent had an illegal substance running through her veins. So when you ask yourselves, did the plaintiff bring to you the evidence that you would need, by the greater weight of that evidence, to show that Coach Taylor and her drills were the proximate cause of the decedent's death? You know the answer to that is no. Now, Your Honor, I want to address something. We understand what opposing counsel is saying about the death of the decedent. And we by no way blame the decedent for the effects of the drug. However, we're here today to show you that Coach Taylor is not to blame for that drug either. So for that reason, when you look at that verdict form and you answer question 1, you should feel confident in knowing that Coach Reese Taylor is not negligent nor the proximate cause. And it's actually the drugs that were in Rory Street that were actually the proximate cause. Now, in just a few moments, you'll have a chance to fill out that form yourself. And I'm confident when you do so, you'll find that Coach Taylor is not liable. And I'm confident this is something you will do because the evidence today has proven to you that on September 7th, 2018, while the decedent had a dangerous substance metabolizing in her body, she actually tragically fell victim to the deadly consequences of that dangerous substance. Thank you, Your Honor.
Rebuttal, Your Honor.
Yes, can I set the timer real quick? It's 11:13. Let me set the timer and I'll give you hand signals like I just did, okay?
Yes, sir.
Whenever you start talking, I will start the timer.
You know, I think we heard all we need to hear about how this coach views her responsibilities when it comes to the health and the safety and well-being of her students. I mean, literally, Your Honor, we have a 50-year-old high school teacher telling you that the kids should appreciate the health risk of heat exhaustion more than she should have. That they should have asked if they needed water. They should have asked if they needed a break. That it was their responsibility. Since when is that how high school works? That we hold the teachers to a lower standard than the students themselves, than teenagers. Your Honor, we can tell blatantly that this coach did not care about the safety and the health risk of the students. All she cared about was getting them tough. Anything outside of them getting tough and winning championships, that was their problem. They should have worried about that themselves. But we know one person that definitely appreciated those health risks and who understands those health risks are Dr. Reagan, the expert testimony you heard today, Your Honor. Dr. Reagan came up here by deposition, Your Honor, and explained that it is most likely she died from heat exhaustion. Now, opposing counsel wants you to compare experts. First, Your Honor, we received that medical examiner's report. The medical examiner's report let us know that there was a cardiovascular issue. We knew there was a cardiovascular issue, so we called a cardiologist, Your Honor, not a toxicologist. And opposing counsel wants you to compare certifications. I want to be very clear. Your Honor, when you look at the CV of their expert witness, Spencer Linton, that he's a toxicologist, Your Honor, he has a bachelor's degree. A bachelor's degree, that's it. Dr. Reagan is board certified. A board certified cardiologist that can tell you exactly what's going on with the body, with the heart, and everything going on in this case. That's why we hired Dr. Reagan, Your Honor. Now, Your Honor, opposing counsel wants you to believe that the symptoms were the same. The opposing counsel got up here and said, hey, when you look at our expert report, he told you the symptoms of heat exhaustion are the same symptoms as a cocaine overdose. Your Honor, that's exactly the point. Whether you call it heat exhaustion or cocaine overdose, those symptoms were there. Coach Taylor would have seen those symptoms, and that's why we're here today, Your Honor. It's not about the specific drill that was ran. We know it gets hot all the time here in Waco. It's not about the generalities that existed, Your Honor. It's about that day, September 7th, and what was different about that day. What was different is that Coach Taylor knew Rory was acting strange. Coach Taylor knew that Rory was not being that star player that she was. We heard time and time again that Rory was showing all those symptoms of heat exhaustion, or if you want to call cocaine overdose, the symptoms were there. And when they're there, we have to ask ourselves, how did Coach Taylor respond? When Coach Taylor observed this, how did she respond? And in her response, did she do what a reasonable person would have done? A reasonable person wouldn't have continued the same drills. If Rory showed up to practice with the flu, she wouldn't have continued to run Rory. If she showed up to practice with the cold, she wouldn't have continued to run Rory. It's about the specific situation and what she did knowing those facts, Your Honor. Those students, they didn't have a voice. They knew their opinions didn't matter because all Coach Taylor cared about was getting them tough and winning those games. But Your Honor, you have an opportunity to have a voice for those students, to have a voice for Rory, to hold this defendant responsible for not doing what a reasonable person would have done under the circumstances on September 7th, knowing everything that she knew. Find the defendant responsible. Thank you.
Yeah, I'm going to take my ruling under advisement, and scoring judges, if y'all can hang out, competitors too, until we get confirmation that the ballots have been tabbed. If y'all can send your ballots in to the appropriate place. Good job, guys. Really enjoyed this one.
Thank you.
And good job. It was nice seeing y'all for a minute.